Let us say happy Sunday. Today we are doing quarter explainers that are short, specific, targeted to the very many questions that you have raised about rent and landlords. The question is, have your landlord, you wake up one day and you find he has sent you a notice on text that rent from next month will move from 1,000 shillings to 5,000 shillings? Arbitrary. Somebody calls you and tells you rent imepanda. Kama hauna rent, wewe uhame. So, what is the law that deals with increment of rent? We are talking about the controlled tenancies. In Nairobi, in Kisumu, in Mombasa, in towns where your rent is below 2,500 shillings. The law is settled. If you look at this act we are reading, the Rent Restriction Act, Cap 296, if you look at Section 9, Section 10, and all these issues are dealt with that. What does the law say? If your landlord wants to increase rent, he must go to the tribunal to seek for what is called an assessment. The landlord cannot increase rent without the authority of the tribunal. So anytime you are being told that rent has increased, or you have been served with a notice to increase rent, rush to the tribunal and get that increment nullified, because one must get away of this. So if your landlord increases rent without authority of the tribunal, it is an offense. He'll be fined 4,000 shillings or an imprisonment for a term not exceeding 6 months or both. So you now know, the landlords, the landladies, if you increase rent without the approval of the tribunal, you will go in for a duration not exceeding 6 months. You'll be either be fined a fine of Kenya shillings, 4,000 shillings, or an imprisonment plus that fine of 600, a fine of 4,000 shillings. Then the next question, the second question, is where you have failed to pay rent. You have delayed to pay rent because you either got sacked, you either have a child who's unwell, you have some one or two reasons. You lost a parent, you got an accident, you're in a hospital, but the landlord says you must pay by 5th of every month. Then you find once you delay to pay, some landlords will disconnect water, they will disconnect electricity, they will get the door being carried out. What does the law say? If the disconnection of water, of any utility, you rush to the tribunal. If the landlord or the landlady is found to have disconnected this water, he will be fined Kenya shillings 2,000 shillings or an imprisonment of between one month to 6 months or to both. Then the third question that is there, how does the law provide for eviction? How does the law deal with the question of eviction? The law provides that if one wants to evict a tenant, he can only evict a tenant with the consent of the tribunal. The landlord must go to the tribunal, show that rent has not been paid, and he leaves. then the landlord will be allowed to levy distress. Levy distress is when you get an auctioneer to come and do that. And that is, the notices to quit must be issued under section 15. One must issue a notice. A tenant must issue a notice to leave. The landlord must issue a notice to vacate. So, section 16, and I read it, no distress for rent of any premises shall be levied except with the leave of the tribunal. So today you know the landlord cannot wake up and chase you from where you are staying. You tell the landlord, you have followed the court helicopter, and you have understood that section 16 tells that no landlord can evict any tenant, whether the tenant has rent arrears of 10 years, without getting the leave of the tribunal. That is as provided for in section 16. Then the landlord, it says, section 23, no landlord shall, except with the prior consent of the tribunal, remove anybody from the place they are staying. Then we have some of the apartments. Very many people now have what is called a furnished apartment. You walk in, the bed does not belong to you, the furniture does not belong to you, the sufurias belong to the landlord. You pay for a furnished apartment. If you have rent arrears, can the landlord be allowed to come and carry a chair or a bed for you not to have a place to sleep? The answer is found in section 22, where a landlord of any furnished premises wishes to remove the furniture or soft furnishings or any of them with which the premises were left, he shall apply to the tribunal for permission to do so. Also, the landlord must go to the tribunal to remove the furniture that was there. Then, can the landlord remove the tap and go away with it? Can the landlord remove the cleaners, the sweepers who are sweeping the place? What does the law say? In section 23, he says, any tenant, that is, if a landlord directly or indirectly deprive the tenant any water, any light, any conservancy, any sweeper or other services, the landlord removes those people. The compound becomes stinking. No garbage is being collected. Section 23 says, any person who contravenes this provision shall be guilty of an offense and liable to a fine not exceeding 6,000 shillings or to a term of imprisonment for not exceeding 6 months or to both such fine and imprisonment. So you cannot remove a tap of water. You cannot remove electricity. You cannot remove a generator. You cannot remove the cleaner who is cleaning the toilets, who is cleaning the compound as a landlord. You will be taken to the tribunal, but if you want to do that, you must go to the tribunal to get that. Failure to which, you will get 6,000 shillings or imprisonment for a duration not exceeding 6. What about the landlords who refuse to repair? Have you ever called your landlord, you tell him the sewage has broken, water is drilling, the rains have come, like now, it's a chilly Sunday, the rains have come, they are dropping into where you are sleeping, water is seeping in. The landlord does not care to repair. What does the law say? Section 26 provides that if the landlord fails to maintain the premises in a state of good status, he will be found to have committed an offense and he'll go in for a duration of 6 months or a fine of 2,000 shillings. So the landlords must make the house what is called a house that is habitable. It is not a privilege. Landlords are paid rent and they must maintain the premises for that purpose. What about those landlords who want you to leave? They decide to make an offense called annoyance. Do you know there's an offense a landlord can commit called annoyance? For example, the landlord decides to get, this is a community where families are staying, the landlord puts in one of there are 20 single bedroom, single roomed houses, he puts a bar in one of them. And here the levies come. That is an annoyance. He leaves. 2, the landlord decides to remove the door. That is called an annoyance. 3, the landlord removes the windows. That is an annoyance. The landlord, if he commits an annoyance, Section 29 says, a landlord and any agent or servant of that landlord who evicts a tenant without the authority of a tribunal or willfully subjects a tenant to any annoyance with the intention of inducing or compelling the tenant to vacate the premise or to pay directly or indirectly a higher rent for the premise shall be guilty of an offense and liable to a fine not exceeding 6,000 shillings or to imprisonment for a term not exceeding 6 months or both to imprisonment. So this is a story we saw on the social media where the landlord removed the door plus the windows. That is what is called under Section 29 annoyance. He will be fined 6,000 shillings or go in for 6 months. Lastly, where is the jurisdiction? Where is the jurisdiction of the tribunal of disputes? The jurisdiction is the rent tribunals. Where are they found? Only Court Helicopter will bring you this list. Listen to where you get them. The Nairobi Rent Tribunal. It deals with Nairobi County, Embu County, Machakos County, and Kajiado County. So if you fall in Kajiado, Machakos, Embu, you come to Nairobi Rent Tribunal. 2, the second station is called the Nyeri Rent Tribunal. This one covers Nyeri County, Murang'a County, Kirinyaga County, Nyandarua County, and Laikipia County. That is the second rent tribunal. The third one is Garissa Rent Tribunal. This one covers Garissa County, Wajir County, and Mandera County. The fourth one is the Embu Rent Tribunal. It is stationed at Embu. It covers Embu County, Meru County, Kitui County, Isiolo County, Marsabit County, and Samburu County. Then we have Mombasa Rent Tribunal. The Mombasa Rent Tribunal deals with Mombasa County, Kwale County, Taita Taveta County, and Lamu County, and Tana River County. Then we have the Nakuru Rent Tribunal sitting in Nakuru. It covers Nakuru County, Narok County, and Baringo County. We have the Kisumu Rent Tribunal, which has jurisdiction to deal with Kisumu County, Homa Bay County, Siaya County, Nyamira County, Kisii County, and Kericho County. Kakamega Rent Tribunal It has jurisdiction to hear matters of Kakamega County, Busia County, and Bungoma County. The last one is Eldoret Rent Tribunal. This one has jurisdiction to hear matters in West Pokot County, Turkana County, Elgeyo Marakwet County, and Nandi County. Today, you now know all these disputes about rent, about utilities. We now have told you the court helicopter has brought to you issues about rent and matters about landlords. Wakili Danstan Omari, always wishing you all the best from Court Helicopter News. Thank you.